Question number 7. Cynthia is asking, how can we protect our intellectual property and ensure that our manufacturing process and product designs are kept confidential? So here are some ways to protect your intellectual property and manufacturing processes. I have to say that I'm not a lawyer and this is not legal advice. For any legal advice, I recommend you to talk to your attorney. So the first thing would be to file for patents. Anywhere where you can protect your intellectual property with a patent, you should do that. Patents are a form of legal protection for inventions. They give the inventor exclusive rights to make, use, and sell the invention for a certain period of time. Filing for patents can help protect your manufacturing processes and product design from being copied or used by others. So this is straightforward. The second way would be implement a non-disclosure agreement, an NDA. NDA is a legal binding agreement that prevents employees, contractors, and other parties from disclosing confidential information about your manufacturing processes and product designs. NDA can help ensure that your intellectual property remains confidential. NDA works very well, from my personal experience, outside of manufacturing zones, or let's say in the United States, in Europe, it works quite well. In China, an NDA does not protect you from a third party using your intellectual property. So why? Because the manufacturer is not interested in any breach. The manufacturer will not use your product, but somebody else. The access to manufacturing is that easy that anyone taking your product, just buying your product, goes to another manufacturer and manufactures there. So this NDA does not really help much, so to speak, for someone to come and take it and manufacture. NDA, well, it's good to have it. It just does not protect you much in manufacturing countries. The third one would be to use trademarks and copyrights. Trademarks and copyrights protect intellectual property related to branding and creative works. Trademarks can protect your business name, your logo, and other branding elements, while copyrights can protect original creative works, such as designs and written materials. It is important to get a trademark not only in the country where you sell your goods, but also in the country where you manufacture your goods. And this is a very good protection, because at the moment that you have a trademark rights to your trademark in the country where you manufacture your goods, the manufacturer or any other third party are legally not allowed to reproduce it without your consent. So even if someone starts reproducing your product, they are legally not allowed to sell it in this country. And this trademarking in the country where you manufacture, to start with, is the best way to protect your intellectual property. Of course, followed by the patents or done together with patents, but this one is a very, very potent one, and everybody should do that. Once you've patented everything and you have your trademarks, you have to monitor on infringement and you have to prosecute infringement. And the way number 5 that I would recommend is to manufacture with people, with companies that you know and trust. Why? Because those companies you know and trust, they can know all ins and outs of your product. And while manufacturing, they can separate your product in several parts and manufacture those components in 2-3 different places. Depends on the product. Not every product can be manufactured like that, but the product can be manufactured at one part at one facility, another part at another facility, so nobody outside knows what's really being manufactured. And only one trusted party puts it all together, for example. And only this one trusted party knows then the whole process, and everybody else just knows part of the process. Again, not all products can be manufactured in this way, but for all products counts, manufacture with those you know and trust. From my personal experience, from all these points, which ones are the most effective? The most effective are to manufacture with those you trust and know, to trademark your product in the country where you manufacture. And of course, in the country where you sell, in both. And the third one, to file for patents. So these three are really working very well. NDAs, they do not work in countries that manufacture because access to manufacturing is very easy. Somebody else can take it and bring it somewhere else and manufacture it. It is not difficult. For example, if someone wants to manufacture something in Germany, it's extremely difficult because there are no manufacturing facilities here. But since all manufacturing facilities are concentrated in Asia, someone may consider to take one product, buy it here, and then move to another factory, manufacture it there, and you have not signed NDA with all factories in this country, right?